The court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. Dr. Dean said Planned Parenthood isn't open on Sundays. Perhaps she was actually seen at a Chick-fil-A. What's up, everybody? Welcome back to the internet, where your cesspool is my jacuzzi. This morning, Judge Mata made a ruling in the Clayton Echard, Laura Owens paternity scandal case. And we know the judge ruled in Clayton's favor, and we were able to kind of skim through that reading earlier today. But just in case you don't have that much time to listen to me talk, I'm going to try to summarize it for you really quickly here with the important points. The first part of the ruling document is just going over the procedural history, talking about the filings and what happened in the case. There are just a couple of things in here that I thought were really good to read. Here the judge is talking about the injunction against harassment hearing. She notes, petitioner appearing virtually frequently stood up and rubbed what appeared to be a swollen abdomen. Testimony resumed, and petitioner testified that she was 100% and 24 weeks pregnant with respondent's children. So that's important. Now we get into the findings of fact, and this talks about petitioner Laura Owens. Now, I think most of us are pretty familiar with this case, and so I won't go over the stuff that's going to be a little more redundant that we've talked about to death. Now, the judge notes here that Laura's implication that Clayton initiated sexual intercourse without consent was not in the initial court filings and was not alleged until 2024. At trial, Laura testified they had sex and that it was rape. She testified she has been pregnant 4 times. Each time, the alleged father believed she fabricated the pregnancy and doctored medical records. So this part's important here. In the something to consider email, the court finds the language to imply respondent was attempting to buy into the idea that rubbing or grinding their genitals together might have led to a pregnancy. The court, however, does not find the email conclusive that respondent believed her to be pregnant with his children, but rather an attempt to consider her assertions. So that email that she's referring to is the one where Clayton was saying maybe this medication is what caused the positive. So it's basically saying the judge doesn't find that Clayton definitely thought Laura was pregnant. It's just that he was trying to figure out how that could be true. Petitioner denies sending respondent an ultrasound video, citing instead that Greg Gillespie hacked into her email and sent the video to respondent. That is ridiculous. I've said that over and over again. I've shown how you could easily prove that Greg Gillespie had hacked if he had actually hacked. So that would be the easiest thing in the world for her to do. It would take just a few seconds, and yet she won't do it because it's not true. It's a lie. Greg Gillespie did not hack her. Greg Gillespie did not send that email. Petitioner testified that July 2nd, she anonymously sought care at a Planned Parenthood in Los Angeles. She failed to provide the records of any appointment, anonymous or under an alias. Clayton presumably sought records from all Mission Viejo Planned Parenthoods because that's where Laura said she had gone to seek care up until the day of trial. Laura testified she had the sonogram at Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent Clayton from tracking down the records. The court was not provided with those records at trial. It's because they don't exist. It's talking about Laura's testimony that she, passed the less than hand-sized sacks. She took pictures and sought telehealth assistance. Telehealth provider told her it was hard to tell if she miscarried because it's a telehealth provider. And also, didn't she just text a text line? No. The court finds the hard-to-tell component of the telehealth visit was due to the nature of telehealth and the inability to provide care in the form of an exam, HCG test, blood test, ultrasound, or sonogram. Instead of seeking in-person care, Laura chose to take another HCG home pregnancy test on July 25th, which was positive. Laura again took a home test instead of seeking care on August 1st. So the judge is really, seeing through her bullshit, obviously. Dr. McCool's records indicate 44 pages of records confirming, making, and canceling appointments. Thanks for turning over those medical records. The court was not provided with evidence of the positive COVID test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. Yikes! The court does not find the sexual contact between petitioner and respondent resulted in a pregnancy. So the court is saying Clayton did not get Laura pregnant. The court finds that if the petitioner was pregnant, it is profoundly unlikely that conception occurred because of rubbing, grinding, or oral sex. Here the judge is saying if she had been consistent in her allegations of sexual assault, had a police report or a physical exam, they might find differently, but her evidence and testimony do not support that inconsistent contention. Petitioner testified on October 18th she was aware the alleged pregnancies were not viable and filed the request for pre-decree mediation in the hopes that at mediation she could tell the respondent that the pregnancy was no longer viable. That is... Okay. Upon denial of her request, she did not file a motion to dismiss or make other arrangements to advise respondent of the development. So that was in October. The court finds this testimony uncredible and a misuse of judicial resources. Petitioner was not treated by Dr. McCool or Dr. Higley as testified to in her November 2nd hearing on the injunction against harassment. Petitioner's alleged pregnancy was not treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable. The court further finds that going to Banner for a pregnancy test, but not the passage of fetal tissue, to be unreasonable and uncredible. So the judge is saying if she were reasonable, she wouldn't have gone to urgent care for a pregnancy test, but then not gone to urgent care for a possible miscarriage. Petitioner denies tampering with HCG tests, but does admit to altering and fabricating ultrasounds and sonograms. She further testified that she changed the HCG numbers on 2 of the results. The court finds little, if any, difference in altering the test itself, for which she denies, and altering the results, which she did tamper with by her own admission. During petitioner's cross-exam, it became profoundly obvious that counsel for the petitioner was attempting to coach her answers. Respondent's counsel, identifying the issue, moved between counsel and the petitioner. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. Court had to remind the petitioner twice that counsel would ask a question and she needed to answer it. At this time, petitioner pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner to no avail. I was really surprised she talked back to the judge after the judge explicitly told her, you need to answer the question yes, no, or I don't know. She would not do it. That was by far the most interesting and high-stakes tantrum I have ever experienced in my life, and my sister and I used to cry a lot, for very little reason. God, where was David when I was doing my public speech presentations in high school? I could have used a little coaching back then. The court finds this interaction between counsel and petitioner diminishes the credibility and veracity of the petitioner's responses during cross-examination. At this time, petitioner became emotional and asked for a brief recess, which the court granted. So here she's saying the court can't determine the date of any alleged miscarriage, not because it's impossible, but because Laura failed to seek even a minimal level of care for her high-risk condition. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure Clayton would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted. This whole ruling just feels like one giant roast of Laura Owens' storytelling. Here we're talking about Dr. Medill. Dr. Medill testified none of the medication records he reviewed would cause a false positive home pregnancy test. However, as mentioned before, when he was being crossed, it was pointed out that he never got records from her PCP or an OBGYN. This was the most bizarre thing about his testimony. Dr. Medill testified that he is 99.9% sure that the petitioner was pregnant based on the HCG tests. He did not change his perspective after petitioner's admissions on the stand that she altered more than one test to reflect higher, viable HCG numbers. Here's where some of her past crimes come to bite her in the ass, too. The court finds Dr. Medill's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility. Yikes. Guess you shouldn't have faked that cancer, huh? Especially given that records that the petitioner testified existed were not presented to her own expert for review and consideration. Dr. Medill never saw that Planned Parenthood record, did he? While Dr. Medill testified that a non-viable pregnancy is still a pregnancy, the court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for Clayton to believe that she was still pregnant with viable fetuses. Dr. Medill concluded that the petitioner became pregnant on May 20th and ended with a spontaneous abortion, late October, early November, or possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. This is like one of my favorite parts. Dr. Medill testified that women may expel tissue during a spontaneous abortion, or the pregnancy might remain in her body, ultimately being reabsorbed. Given that the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant and had seen her doctor, presumably in person, the court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. The court further finds a miscarriage at this stage of pregnancy would result in emergency medical care and corresponding death certificates of twins. If what Dr. Medill testified to is true, and she miscarried much sooner, negating the need for the death certificates, then petitioner perjured herself at a prior hearing. Then we go on to talk about Dr. Dean's testimony, which is much less controversial. Dr. Dean's testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. They're required to provide a government-issued form of identification. Dr. Dean said Planned Parenthood isn't open on Sundays, but Laura testified that she sought care at Planned Parenthood on July 2nd, 2023. A Sunday. Perhaps she was actually seen at a Chick-fil-A. Dr. Deans testified that HCG does not confirm pregnancy. There has to be serial HCG, so like HCG that's trended over time, or an ultrasound and exam, which were never done or never disclosed to the court, the respondent, Dr. Medill, or Dr. Deans. Dr. Deans reviewed the July 23rd telehealth instructions that petitioner proceed to an emergency room for additional evaluation and care. The instructions were not followed, but petitioner called the abortion and miscarriage hotline, which also recommended and encouraged the petitioner to seek in-person medical care. A prior history of ovarian cancer could also produce a positive HCG result. After reviewing the records, Dr. Deans determined that the HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. All right, here are the findings on Clayton Echard's side. Respondent testified that petitioner sent him approximately 500 texts using 13 different phone numbers, threatening to leak information to the media. Respondent testified that petitioner reached out to the son, called his family, co-workers, and prior girlfriends, accusing him of being a deadbeat for not supporting her and the twins. That's fucking crazy, even if you are pregnant. If you're bringing someone to court and trying to establish a parenting plan and you think you might want to co-parent with this person, don't do that. Petitioner emailed respondents. You can't say you haven't been given a voice when I have told you I will have an abortion if we try things out for a few weeks and have a good reason for aborting the child. How is that a good reason for aborting the child? That should not factor into your decision to be a mother or not. These words feel menacing because you know I like you and I want to try things out with you. Well, I like you, so you can't be mean to me if I'm harassing you. Petitioner encouraged respondent to have sexual intercourse with her, citing she was tight and already pregnant. That never gets easier. If you think about it, having sex with me is the safest thing you can do at this point. I'm already pregnant, and if we choose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills. So there's no risk. That's crazy. Not clinically insane, but crazy. Petitioner said the twins were a boy and a girl, provided a sonogram that was posted on YouTube 7 years ago, and she admitted to that in her deposition. Petitioner sent a threatening letter, and this is talking about the kind of extortion attempt where she said she would sue him for $1.4 million if he didn't drop this stuff. And then this is talking about her releases for records from Dr. Higley's office, where they advised, we have no record of treatment for the dates of service you requested. Okay, a lot of this is getting into other case stuff, so I'm going to skim over a lot of this part just to get to the important parts. The parties admittedly had a relationship that was previously romantic or sexual, however fleeting it might have been. Petitioner thus had a statutory avenue to seek a protective order, regardless of whether she fabricated her pregnancy. Moreover, Commissioner Duty did not issue the order based solely on, or even primarily on, the fact of petitioner's pregnancy. His initial order required respondent not contact petitioner or communicate or post untrue or harassing comments regarding the plaintiff online. Moreover, petitioner's initial petition referenced a myriad of communications respondent made to her that could be deemed threatening per the statutory guidelines and appears to have prompted Commissioner Duty to confirm the order after the hearing. Thus, even if petitioner's broader pregnancy allegations are proven untrue, one aspect of the court's order indicated that it found respondent had engaged in harassing conduct, so even on the merits there was no cause to invalidate the final judgment. Here we're getting into the subject of sanctions. By signing a pleading, motion, or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief, formed after reasonable inquiry, 1. It is not being presented for any improper purposes, such as to harass. 2. The claims, defenses, and other legal contentions are warranted by existing law. And 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. If a pleading, motion, or other document is signed in violation of this rule, the court, on motion or on its own, may impose the person who signed it, a represented party, or both, an appropriate sanction. which may include in order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney fee. Can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion? David Gingras thinks not. The judge writes here, as already noted above, the rule expressly provides that the court can sanction a party for violation on its own. Clayton is seeking to have the protective order invalidated because of the alleged fabrication, where he believes Laura faked her pregnancy. Laura argues that even if she wasn't pregnant, the sexual activity between them and his subsequent harassing online conduct are sufficient to sustain the order regardless. Let's keep in mind that the harassing online conduct was alleged. She blames him for being like multiple Redditors and stuff like that in a police report, didn't she? I'm pretty sure she did. It was either Clayton or Greg or both that she had like reported to the police. There are a bunch of different Redditors, and there was like no evidence to support that at all. If the court were to here find that petitioner fabricated her pregnancy to provide leverage against respondent in order to secure a long-term relationship with him, sorry, I can't, and all its attendant benefits, Rule 26 would appear without doubt to provide the authority to order her to pay respondent his reasonable expenses, including a reasonable attorney fee. That's because that fabrication, if adjudicated as such, would have been the predicate for her initial petition and many, indeed all, of the motions that came after it. A man is presumed to be the father of a child if genetic testing affirms at least a 95% probability of paternity. Well, that doesn't really help in this case because the testing is ongoing. Based on a lack of confirmed pregnancy and repetitive Ravgen results of little to no fetal DNA, the court cannot establish that petitioner was pregnant. The court cannot establish paternity of an unconfirmed pregnancy lacking DNA evidence despite testing twice. Here, 2 test results of little to no fetal DNA fall woefully short of the 95% required to meet the burden of clear and convincing evidence that respondent was the father of petitioner's alleged pregnancy. Now they're just talking about the governing rules for attorney fees and costs. Okay, here we have the court findings. The court finds there is no substantial disparity of financial resources between the parties. Petitioner did not provide an AFI but testified she and her mother collectively earned $200,000 a year. Respondent filed an AFI on May 15th, citing monthly income of $12,000 and an annual income of $144,000. The court further finds that petitioner acted unreasonably in the litigation. Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit. Without an authentic ultrasound, sonogram, physical exam, and in conjunction with a belief she passed tissue in July 2023, the court finds the underlying petition premature at best. At worst, however, fraudulent and made to incite communication, a relationship, or both, with the respondent. The court further finds that filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursement for those costs. The court further finds that petitioner repetitively failed to comply with Rule 49, even on the order of this court. Further compounded by the fact that on the day of trial, she testified that she anonymously sought care at a Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged that she altered HCG test results, an ultrasound, and a sonogram. The court further finds that provisions of ARS 25-324 do apply because the petition was not filed in good faith, the petition was not grounded in fact or based on law, the petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds petitioner provided false testimony as to the viability of the pregnancy in all 3 cases addressed in the procedural history. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss his action that she initiated. The court further finds that Laura Owens knowingly presented a false claim knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate. It is therefore ordered granting Clayton Echard's request for attorney's fees and costs. It is further ordered denying Clayton Echard's request for attorney's fees and costs associated with the OOP and IAH, referencing the analysis above. It is further ordered granting the respondent's petition for non-paternity. So the court has found that Clayton was not the father of Laura's twins, alleged boy-girl twins, which came from a blowjob. 2 blowjobs, 2 babies, I guess. It is further ordered, the court having determined that Laura Owens has a pattern of similar, if not identical, behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for review of Laura Owens' actions pursuant to ARS 13-2702 and ARS 13-2809. Accordingly, the Maricopa County Attorney's Office will be endorsed on this order. The court must decide the amount of attorney's fees and costs to be awarded, but finds there is no just reason to delay making a final order. As we know, David Gingras and Laura intend to appeal. He tweeted that out this morning, and we'll see how that goes. But when he does decide to share his thoughts, I'm sure that's something we'll talk about. I mean, we kind of knew that was going to happen because he was pretty much saying he was going to appeal before the trial even happened. So I don't think they thought they were going to win this one, but she's never been in this kind of trouble before, as far as I know. So we'll see how they decide to respond to that. Diminishes the credibility and veracity of the petition was filed for an improper purchase. Improper purchase. It was by Fi. Whoa. By Fi. The court finds it as bleh. It mentions Laura testified to the validity. Validity. I can't say validity. Validity.